2, 1.
Good afternoon and welcome to the Moses Kotane virtual lecture under the Corporate Services Unit. We're talking digital communications. Today we have a guest lecturer who is going to give us cyber law and security information. Basically, he will be giving us an overview of the South African cyber law. His name is Professor Snail Sizwe Mtuze, who is a practicing attorney under Snail Attorneys in Gauteng mainly. He is a professor at the NMU and a fellow at the UFH. He is a member of the Information Regulator of South Africa. Thank you for availing yourself, Prof. Over to you. Thank you.
Thank you very much, Advocate, and thank you for having me today. I am very happy to be your guest lecturer for the day. I don't want to waste a lot of time with these online things. I want to go straight into the slides. You will notice that initially I had said cyber law and cybersecurity, and then I thought, you know, the Protection of Personal Information Act is just around the corner. And I've also noticed that of late, we've been receiving a lot of cyber criminal emails, people trying to siphon us of money. So I decided that, you know what, maybe the best thing is, let us talk about cybersecurity, cyber crime, as well as the protection of personal information. So before I want to go into the meat of it, I need to tell you about the Information Regulator, and that is the logo that you see at the bottom left of the screen. The Information Regulator is an independent body that was created in terms of the POPIA, the Protection of Personal Information Act. And in terms of that, the regulator mandates, basically stretches over the right to privacy on the one hand, and right to access to information on the other. Initially, the POPIA only had limited sections that were of force, but as of the 1st of July 2020, the grace period has commenced. I'm sure everyone has heard about the grace period of POPIA. So that is a 12-month period which enables people to comply with the prescripts of POPIA, so that when the 1st of July comes, people should be compliant. Also, very interestingly, the POPIA has also amended the PIA. I'm sure we all know the Promotion of Access to Information Act. Previously, if you were not getting a PIA request satisfied, you would have to approach a court of law. In terms of the amended sections of the POPIA and the PIA read together, the Information Regulator now has jurisdiction to deal with disputes pertaining to access to information. Just to give a brief overview of the terminologies that I'm going to use. When I talk about a data subject, I'm talking about yourself and myself. In other words, a person to whom the personal information relates. You will notice that in South Africa, a person can also be a juristic person, right? And then we have what we call a responsible party. For those of you who've read the GDPR, that is the General Data Protection Regulation of the EU, a responsible party is usually referred to there as a data processor or a data controller. But in terms of our legislation, a person who processes personal information of a data subject is known as a responsible party. Then we also have the party that processes personal information on behalf of an operator, on behalf of the responsible party, and that would be known as the operator, okay? So we have three role players: the data subject, you and I, the responsible party, the person or private entity or public entity that you entrust your personal information with, and the operator. And this may be a third party who may be processing your personal information on behalf of the responsible party. Very interestingly, in terms of our legislation, a competent person is a person who can legally consent to the processing of personal information. Therefore, children and anyone who's under the age of 18 cannot consent to the processing of personal information. Now, what exactly is personal information? Let us just give it a short and crisp definition. Personal information is information relating to an identifiable living natural person. An identifiable living natural person. So you must be able to identify me, Sizwe Snail Mtuze. I am a natural person and I'm still living. So I can be the subject matter of personal information. On the other hand, when it comes to a juristic person, it must be an identifiable juristic person that exists. So a company that is wound up or a partnership that doesn't exist any longer, that would not be an existing juristic person. What is very, very important is that in the definition of personal information, we say personal information includes but is not limited to. And then you will see there in the definition, I think it's section 2 of the POPIA, it lists various types of things that could be deemed as personal information. But what is important is the word but not limited to. In Latin, they taught us there's no numerus clausus. There's no closed number as to what personal information could be. But some of the examples that they make is race, gender, your sex, pregnancy, your marital status, your nationality. I know we as African people, we like to tell each other about our ethnicity and our social origin, our color, our sexual orientation. I think in 2021, people are very vocal about their sexual orientation, their physical or mental health, their well-being, as well as their consciousness, be it political consciousness, belief, culture, or religion. And this extends to information relating to your education, the fact that you had an H in woodwork in matric many, many years ago, that is your personal information. It is not for public consumption. I also know that in South Africa, for the last 20 years, if you had a particular disease, they would say you need to disclose such a disease, but that would also be medical information, including financial information. So the fact that your neighbor who drives a flashy sports car actually is not paying the bank properly, that is also his affair with the bank. Now, very interestingly, just to show you the interaction of the data subject and the responsible party, as well as the operator, I thought that I would take us to a case that we all know about, but we just don't know that the Information Regulator was the 8th respondent in this matter. And that is the case of the Black Sash Trust versus the Minister of Social Development and others, and the 8th respondent being the Information Regulator. To cut a long story short, the complaint by Black Sash was that the grant beneficiaries, in other words, the data subjects, were receiving unsolicited emails, unsolicited telephone calls, selling them products, getting them auto-subscribed, and literally attacking the grant beneficiary money. By the time some of them would get their money, all lots of deductions would have been done. And the question was, but how did these companies get to the grant beneficiaries? How do they get to the data subject? And SASSA then was held to have a duty to ensure that they protect the personal information of the data subjects, and that the operator who was processing the personal information on behalf of SASSA was then also ruled to have, transgressed POPIA, and they were then also ordered accordingly to put in safety guards to ensure that when they are processing personal information of the grant beneficiaries on behalf of the responsible party, that they make sure that there are safeguards to protect the personal information of those grant beneficiaries. A very interesting case groundbreaking constitutional court jurisprudence there. Then, very interestingly enough, it's not just about the POPIA. On the same day that the POPIA last year was put into the grace period, the cybercrimes bill was also at that stage then sent to the office of the president. Now, what is the significance of cybercrime bill on the other hand and data protection, or the POPIA, on the one hand? Well, on the one hand, the POPIA protects personal information and prescribes how we should process personal information. There is a requirement there that talks about safety and security guards, but we'll get to that. And then the cybercrime bill, that would then effectively repeal the sections pertaining to cyber criminality, which we have in the Electronic Communications Transactions Act of 2002. So just briefly, what exactly are the salient provisions of POPIA? The salient provisions are the conditions for lawful processing. I call them the principles of lawful processing. And they're basically accountability, process limitation, purpose-specific, further processing limitation, information quality, openness. I told you about security safeguards and data subject participation. And I told you that the seventh condition is the most important one for this context, because it is the one that talks about safety and security guards. In other words, a responsible party now has a positive duty. He or she or it who collects personal information of data subject now has a personal duty to, and a positive duty to protect the personal information. Number one, ensure that there are technical and organizational and appropriate safety measures put in place. And in doing so, a four-step analysis has to be done in terms of your own organization. What are the risks pertaining to the information that you have? The establishment of proper and appropriate safeguards, in other words, processes in place, verification of those processes and implementation thereof, and regular updating of safeguards. The cyber criminals are not waiting for you to update your measures. Now, what is very important, in the event of a data breach, we've all heard about the data breaches. We heard about Experian. We heard about, there was a Nedbank one as well. There was the British Airways one. There was a Momentum one. There were several data breaches that we had last year. The public ones, there were also some that were private, which the regulator unfortunately cannot disclose. But in the event of a data breach, there is now a positive duty upon the responsible party to notify the data subject. So not just do you self-report to the regulator, but you must now notify the information regulator of the fact that you have suffered a data breach. And these are the people who have been affected, and these are the measures that we have taken to ensure that the breach doesn't happen again. On the other hand, the notification to the data subjects is to ensure that data subjects are aware that, in fact, a data breach did occur and that they can be vigilant if they see any funny ITC activity, any funny withdrawals from their accounts, that they can now be vigilant because their personal information was one of the personal informations that was compromised in the data breach. Now, like I said, the data breach effect then goes also into cyber criminality. Not all data breaches are acts of cyber criminality. Some of them are acts of negligence, but some of them are actually intentional cyber criminal acts. So once you are done with the data protection aspect, once you've notified the data subject, you've self-reported to the regulator, you must then also make an assessment if there was any intentional or unlawful accessing of the computer system, any intentional or unlawful interference with the data, any computer-related extortion, fraud, or forgery. That is then the investigation that you need to make. And should there be a prima facie case, you then need to report this to the cybercrime unit of the South African Police Services. We have now also, over the last 5 years, had legislative changes pertaining to the ECT Act. I mean, the ECT Act came out 18 years ago, and we now do have the Cybercrimes Bill that makes provision for more offenses pertaining to cybercriminality, harsher penalties when it comes to penalties of people who are found guilty of these offenses, and hopefully the president will be signing that into law in the not too distant future. Just briefly, it's very important to know that there are 3 types of categories that we now will have in terms of the bill. There will be offenses against the integrity and confidentiality and availability of data, offenses against computer programs, data storage mediums, and computer systems. And then there will also be offenses committed or facilitated by means of the computer. So those are the crimes which I call BC crimes, before the computer. In other words, fraud and forgery, those were computer before the computer. And then we also have the crimes after the computer, and those were the computer specifically that we can do using the computer, as well as aggravated offenses thereof. So because of the time, I couldn't go in depth into what are the penalties regarding POPIA in the event of a breach of the 8 conditions. But I can tell you that in terms of Section 72, 73, 74, there is a complaint mechanism in terms of which you can complain to the Information Regulator if you believe that your personal information has been processed inconsistent with the 8 conditions that I set out before. So that is the conclusion of the formal aspect of the presentation. I thought maybe we would leave some space for some Q&A. If I can give back to the conference chair to give us further direction on that. Thank you very much.
Wow, thank you so much, Prof. Sizwe Snail Mtuze, for such an informative lecture. We will allow for questions, if there are any questions from the audience.
If there's no questions at this stage, Advocate, looking at the time, maybe one could go into the conditions that I mentioned, the 8 conditions. Maybe one can go and unpack those, if you don't mind, Chair.
Yes, please proceed to unpack the conditions, Prof.
Okay, just a moment there. I just want to get to the relevant slide. I just didn't want to fall foul of your time. So, as I said, there are 8 conditions that I mentioned. You're going to see my screen in a moment. There are 8 conditions that we have, and the first condition that we have is the condition of accountability. So he or she or it who processes personal information of any data subject is accountable to the data subject. So the moment I take your personal information, I am accountable to you for what happens to it. In other words, should there be a breach, should there be an abuse thereof, I can hold you liable, I can hold you accountable. So that is the first principle. The second principle comes to processing limitation. And if you look at sections 9, 10, 11, and 12, and I will send these slides to, in fact, I've already sent these slides to Advocate Mapipa Ndlovu. I hope you can distribute them to your constituency there. The second condition relates to process limitation. So it talks about lawful processing. In other words, if you are processing my personal information for an illegal purpose, for a cyber criminal purpose, then it will fall foul of that. You must get the information directly from myself, You cannot go to a data bank somewhere, as they say, and collect my personal information and use it. It needs to be collected directly from me. There needs to be consent. I told you about consent. It must be consent by a competent person. It must be willful consent and informed consent. So consent there has 3 levels: competent person, willful consent, informed consent. And that was one of the issues that we were raising with WhatsApp in the last couple of weeks regarding their wanting to change their conditions of use. The fact that it appeared as if they're forcing people to consent and not willful consent. But we'll see how that goes. And then, like I said, the information must be collected directly from the data subject. Oh, and most importantly as well, the concept of minimality. I used to hate going to seminars and conferences, and there would be this attendance list. It would ask you for your name, it would ask you for your number, it would ask you for your email address. Some of them absurdly would even ask you for your sex. And really, I mean, why do you need all of this information? You know, if you're only trying to establish who came and who did not came, I'm sure a name and a signature would do. So, you know, that is the whole minimality processing. So those are the 4 subjects that fall under process limitation. Then we have purpose specific. So if I go to the bank and I apply for a loan or apply for a credit card, right? I should not be leaving the bank and getting a phone call from a related insurance company or an insurance company within the group of companies asking me to sign up to the insurance, because the information I gave to the bank was specifically for the purpose of me obtaining a loan, right? This then also goes to the aspect of retention. How long do you keep the information? You keep the information for as long as you are still necessary using it to help the data subject, be it a contractual agreement, be it ex lege, in other words, by law, a legal obligation, be it in terms of safety and security of the country. Those are some of the exceptions that fall into that. Then further processing limitation. If you go to your doctor and you ask your doctor to do a blood test for you, the doctor cannot now take the results of that blood test and share it with a research project in America. I mean, that now is even worse, because now then you have trans-border sharing, which would also then fall within the ambit of Section 72. And Section 72 basically says you can't share personal information with a person or a company in a jurisdiction that does not have the same adequate data protection laws like we have. So that's further processing. Information quality is a relatively straightforward one. If you keep my personal information, you must keep it up to date. Openness, that is the one that relates to cookies. No, not the cookies that we eat with coffee or tea. It's the cookies that pop up on your computer screen if you go to your favorite newspaper website, your favorite music website. It says, do you accept cookies? What exactly are those cookies? They are means by which the website takes information about you, your IP address, your region, what time you're logging in. This is all personal information that they are collecting to either make your service better or to try and improve their service or to target particular data subjects. So that is the openness principle. I've already taken you to the safety and safety and security safeguards. Number one, you know, the technical and organizational measures. What are technical measures? Your computer, your physical locking of the safe. It does not only apply to computers, but also to our physical state. And then the organizational measures. What is the organizational measure? What we're doing right now is the organizational measure. Educate your people about data privacy, educate them about the 8 conditions, let everybody within the organization know that there's a thing called data protection. When you go home tonight, discuss with your spouse, discuss with your children, share the fact that we have now got a new legal dispensation where our personal information is protected from abuse. So that is the organizational aspect which I'm talking about. Then I said in the event where you do use an operator, such as in the Black Sash situation, you must have a written agreement with that operator that they will protect the personal information to the highest standard as well. And then obviously in the event of a breach, I told you about the self-reporting to the data subject and the self-reporting to the Information Regulator, right? And then the last one is data subject participation. When you don't want to have your data by that person kept anymore, when you don't want to be on that database anymore, you have a right to ask them to delete the information, or you have a right for them to amend the information. So that basically is an unpacking of the 8 principles that I told you about of POPIA. And these 8 principles, they are valid and enforceable on every day of the week. So you don't choose which principle that you're going to respect on Monday or on any other day. You need to respect all 8 principles on every day of the week. Does it apply to government as well? Does it apply to private companies? Of course it does. What about those who by law are authorized to process information? Home Affairs, SASSA. I think we saw very, very clear with the Black Sash case to say that even government, when government processes our personal information, government has a positive duty to ensure that our personal information is not being abused. POPIA is not here to stop intergovernmental exchange of information. POPIA is not here to inhibit the processing of information. No, no, no. That is something that really needs to be made very clear. But we are saying is, if you process personal information, you need to be aware that there are these 8 principles, and these 8 principles do inform us how we should keep the information safe, how we should process the information, and how we should act in the event of a data breach. Thank you, Chairperson.
Wow, that's a mouthful. Thank you, Prof. I do have a few questions from the audience. I think one you've covered partly. The question is, what do you do in case there is, in case you discover that your information, personal information, has been stolen? I think you touched on the reporting of Sash to the Information Regulator.
That's correct.
But maybe if you can just unpack how does it work? How do you report? I do have other questions that are coming through. You can deal with this one.
Let's deal with the laying of a complaint. A complaint needs to be in writing and must be addressed to the regulator. You will see at the end of my slides there was an email address, inforeg@justice.gov.za. That is the Information Regulator's email address. You will find it on the website of the email of the Information Regulator as well. And as I said, any breach of the 8 conditions, if you feel that your information has been unlawfully used, if you feel that your information has been unlawfully distributed, if you feel that your information has been unlawfully shared in a group of companies, then you must in writing complain to the Information Regulator. You send us an email, you set out what exactly your complaint is, and you tell us that you feel that whatever the condition that you're relying upon, that has been breached, and we will then get in touch with the responsible party in terms of your complaint. What is also nice is in the event of people who are indigent, or in the event of people who may not necessarily be able to type an email or write an email in English, the Office of the Regulator also has a mandate to assist complainants to get their complaint. Unfortunately, the regulator only has an office right now in Kotane, but we do intend to partner up with other Chapter 9s across the country to have places where complaints can be received, and people who don't necessarily speak English, don't necessarily know how to write, that they can also come and be assisted and file their complaints.
Thank you so much, Prof, for that enlightenment. Another question is in relation to a vicarious liability. You'll find that you give your information to, you mentioned the banks earlier, but the question I have now relates to, the chain, fashion chain stores, clothing stores. Right. You know that I went and opened an account with a store so-and-so, and soon thereafter I discover that my information has been shared. Right. How do you deal with the vicarious liability of the employee of that chain of stores? Do you sue the employee and the company, or the employee, or both? And how does that work?
Okay. As I said, today I'm in my capacity as a member of the regulator, but I see advocate is trying me to be an attorney as well. So I'll try and have both caps on. If you look at Section 99 of the POPIA, in addition to complaining to the regulator, who may also give a fine or other remedial action, right? In that case, we would be obviously reporting the responsible party, so it would not be the employee. But in terms of Section 99, you do have a civil remedy against the responsible party that has, infringed your personal information. Now that I think about it, when our regulator first started, one of our first complaints was from the late His Majesty himself, who had received a phone call from an insurance company, and they had called him by his ID name. I'm sure none of us knows who the late His Majesty's ID name is, and His Majesty complained to us. And as far as I remember, His Majesty then was also going to pursue civil damages, as he had, instructed a firm of attorneys to take the matter further. So yes, there are civil damages that you can claim against the responsible party, in additional to the remedies that the regulator has. And in terms of vicarious liability, and this is now the attorney talking, obviously if the employee did so within the scope of employment, then you can go after the employer in terms of civil damages. I hope that answers the question, Chairperson.
I hope so too. On my side, yes, I'm answered. I'm not sure, but I think, yeah, the answer is very much clear. We're doing, and we are still doing COVID questionnaires, and we give out personal information there. And if you don't, you are not allowed entry into certain buildings. How do we deal with that?
Yes, the whole situation with COVID was also very interesting. I mean, the regulator ended up issuing what we call a guidance note. If you go on the website of the Information Regulator, at the time when we had our first lockdown, we received ample of complaints, and even the portfolio committee came and asked us, "Hey guys, what are you guys doing about COVID?" And at the time, government had appointed the COVID judge, the COVID privacy judge, to tackle with those matters. Our office then proactively interacted with the COVID judge, whose mandate then ended, but we then issued a guidance note in terms of which we said, government, in terms of the laws, the laws relating to the Natural Disasters Act, government had an obligation to collect this information. The Department of Health had an obligation to collect this information in order to combat the spread thereof. So it was a law. It was a law that was authorizing the collection of that information. So there we didn't have an issue. The issue that we, however, did have was how that information then is stored by the Department of Health, by the respective service providers who do the tests. And that is where we then said that even although they are lawfully collecting this information, the 8 principles still apply. I mean, I remember there was once a news story about my beloved Eastern Cape province where there were results of COVID-19 patients scattered all over the highway and thrown there, you know, and that was very scandalous, you know. I mean, the department should have never allowed that. But these are the type of things where we say that even government has a positive duty to respect data protection. Thank you, Chair.
Thank you. Okay, other comments that I'm getting, they're just commending you on your eloquency and a very informative session. Yeah, and you mentioned that we need to get written consent, and you said the consent must be by a competent person. You mentioned willful. It must be given willfully, and it who is competent to give the consent, and how do you unpack that? I'm taking you back to your legal practice.
Yeah, yeah. Like I said, you know, a competent person is a person whose whole faculties are working, someone who's sound of mind, someone who obviously doesn't have any form of impairment, and very most importantly, it is someone who's of age. I remember when I was still in university, you know, the Majority Act changed from 21 to 18. So anyone who's of age, who's 18, can give consent. But once again, I stress willful consent, informed consent, right? And so that must be willful and informed. And what is very important is, you know, I know we give our children our cell phones to keep them busy. We give them our tablets. They load applications. We are actually not aware that they agree to a whole lot of things when loading those apps. Can our children actually agree to those things? My humble submission is that they would not be able to agree. Now, this is where chairperson will have to put on a cap as an advocate and say, but what is the legal position regarding the service provider who had the impression that the data subject was of age? I mean, that's a topic on itself, you know. But the general rule obviously is you need to be of age, you need to be 18 to give willful consent, and you must be aware of the terms and conditions that are being put there.
Thank you so much, Prof. And just to add on that, you must be of a sound mind. You must have a sound mental capacity to consent. That is part of that competency, that is part of that willfulness, and that is part of that being informed of what you are consenting to. And yeah, we will definitely call the professor again. This subject on its own has opened a lot of other subjects that we would like to engage the prof on in his various capacities. Let me see if we have, no, I think our time is up. We had booked the prof from 12 to 12:40. Our time is now up. Thank you so much, Professor Sizwe Snail Mtuze, for your time. And thank you to the Nelson Mandela University for allowing you to share information with us through their doors. And
thank you very much. Thank you very much, Advocate. And I also know of late you've also been on the bench, so may I be excused, my lady.
Certainly.
My lady.
Cheers.
Bye-bye.